Calling civil action 2023-1341, Andrew Comer versus Northwestern District Attorney's Office. If the parties could please step forward with plaintiff's counsel to the table at the table directly in front of me.
Take it to Rental.
Oh, yes, thank you.
You got it.
Thank you very much.
Counsel, if you could mute yourself on Zoom. And if the parties could please introduce themselves for the record, starting with plaintiff's counsel.
Thank you. Good afternoon, Your Honor. Mason Courts for the plaintiff, Andrew Comer, who is here with me today.
Good afternoon, Mr. Courts. Welcome, Mr. Comer.
Good afternoon, Elizabeth Keeley for the Northwestern District Attorney's Office.
Hey, good afternoon, Your Honor. Pat Hannon for the Northwestern District Attorney's Office.
Welcome to both of you.
Thank you.
All right. So we have competing motions, but I think the plaintiff was the first, or was it the defendant? I've forgotten.
We filed first.
You filed
defense
first.
Filed cross motion.
All right. So then, plaintiff, I'll let you go first. I've read your papers carefully.
Thank you.
I have looked at I've looked at some of the exhibits, mainly focusing on the example documents that you've included in the joint appendix, so you can get straight to the heart of your argument.
Great. So we think that this case really is looking at the space between two SJC decisions, Middle District, so that's Globe newspaper versus District Attorney for the Middle District, which is the 2003 case, and then the more recent Attorney General versus District Attorney for Plymouth District in 2020. So those are the two cases, and there's also the Boston Globe versus DCJIS case, which is somewhat related, and actually maybe I'll start there because I think it has a very clear articulation of the principle, which is that learning about a criminal investigation, arrest, prosecution, conviction, or sentence from a public record, it does not violate the Corey law. They talk about many examples where you can find out information about criminal proceedings. You can get arrest logs, you can get the daily police blotter, you can go down to the courthouse and pull files from any unsealed case, and that doesn't violate Corey. What violates the Corey statute is putting together someone's entire criminal history, and that's really where we get the distinction between Middle District and Plymouth District. So in Middle District, the Globe was seeking docket numbers, names, case outcomes, and sentences for a particular category of cases. It was public corruption cases where the defendant was a municipal officer, right? And the court said that is information about a criminal proceeding. However, you're not getting their entire criminal history. It's a narrow request, and you could identify every public officer in your town and go down to the local courthouse and ask for them by name. That's okay. That doesn't violate Corey. And likewise, this request to the district attorney's office did not violate Corey. So in 2003, they quite clearly...
Let me just ask
yes,
you, the Middle District case, did that case involve names as well as docket numbers? And if not, does that make a difference?
It did involve both. It was docket numbers, names, outcome of the case, and sentence. So
okay.
Actually more information than we would be getting here.
All right.
On the other end of the spectrum, you have Plymouth District in 2020. There, the Boston Globe asked a district attorney's office, actually multiple district attorney's office, for every case in your database. And there, the court said, well, even though docket numbers and associated information are not Corey themselves because they are part of sequentially ordered information from a public docket, if you get all of them at once, you can essentially create a shadow Corey database. One thing that was very important there was that the data would have included identifiers linking cases together. So once you identify that, identifier 1, 2, 3, 4 is Mason Courts, you could look up Mason Courts' entire criminal history. You would essentially do what they called an end run around Corey.
Was that identifier just some internal record-keeping number of the district attorney's office?
That is my understanding. That was
not
an
a
internal
docket number or a public number of any kind.
That's right. It was an internal number, and once you associated a docket number with an internal identifier, all you would have to do is pull that docket once. You would know the defendant's name, and then you could essentially do a name-based query. So Middle District involved a situation like Mr. Comer's request where we're not looking for anyone by name. we're looking for certain circumstances. So in middle district, the circumstances were a particular type of charge and a particular type of defendant. Here, we're looking for a particular type of defendant, police officers. And while it's not limited to a particular charge, it's limited by a different set of circumstances, which is that the DA has determined the offense is the type that requires mandatory constitutional disclosure under Brady. So we're looking again at limited based on circumstance, not based on anyone's name. And most importantly, there is no way based on these records to know if any given offense that shows up is an officer's entire criminal history. If Officer Smith has a DUI, that might be the only charge that's ever been brought against Officer Smith. It might be one of many. We wouldn't be able to confirm that without going down to the courthouse, going to every courthouse, really, and looking for Officer Smith's records. And that's exactly what in all three of these cases, the SJC said is not prohibited by Corey. Putting together criminal history from other public sources is not prohibited by Corey.
Does it make any difference here that it's not just names and docket numbers, which is sort of what's called out in the Corey statute, but also the charge and the disposition of the charge, at least as I saw it?
So they do contain the charge. Not all of them contain disposition, as I understand it, given that the timing of when the letter was written as based on the charge. Some of them were still pending, I think, when the letters were written. Charge and disposition were also disclosed in the middle district case as well, though, I believe. So I think, again, we're looking at a relatively similar universe there. And also because charge and disposition are information that, absent sealing, are available from the judicial records and that you could go down to the courthouse and get, that information wouldn't render this exempt under Exemption A anyway. Only if the query was structured such that it revealed information that could not be obtained from the courthouse in person or could not be obtained from some other public record.
All right. How do you distinguish, and I never remember the names of these cases,
Sure.
the 2020 case, not the Deciduous case, but the
Yes.
other one.
The Plymouth District case.
The Plymouth
Yes.
District case.
So
Is it solely the volume of records, or was the actual information different?
I think volume of records is really the main issue in Plymouth District. So all three cases ultimately came down to this recognition that the release of docket numbers itself doesn't violate the Corey statute. However, the release of docket numbers could undermine the purpose of Corey. So that's really where the court ends up in all three cases is, does this undermine the purpose of Corey? In Plymouth District, it undermined the purpose of Corey by essentially creating a shadow database. That is one way that release of records could undermine the Corey statute. It's possible, and the court left open in Middle District, that there are other ways you could violate the Corey statute. One possibility, for example, would be if you said, I want all records related to a specific address. Well, that would be effectively a per name search, right? So that might violate the Corey statute. Or if you asked for it in reference to information that was not available on the public docket. So if you said something like, I want all charges that were brought against individuals in the Northwestern District against defendants who had juvenile convictions. You wouldn't be able to get that because juvenile convictions are not available to the public, and you'd sort of be backing your way into non-public data. Here, the fact that these offenses were committed by officers, Northwestern District Attorney's Office has not argued that any of them are sealed or exempt otherwise than purely under the Corey statute, which all three cases confirmed that bare names and docket numbers would not be exempt through Corey.
And how many officers are we talking about in this request?
I believe there are around 45 officers. There are many more records than that, but many of them are duplicates. If the same officer testified in 10 different cases, there's going to be 10 Brady letters. I went through and tried to guess which officers were the same officer based on the chances that duplicate charges for two officers were probably unlikely on the same date. Of course, because we don't have names, we can't really be sure, and even then, we would be guessing based on name, not some sort of like really hard identifier. But I think it's somewhere around 40, maybe 50 officers.
Okay. All right. You've answered my question, so then why don't I hear from defendants now?
Thank you, Your Honor.
Thank you, Your Honor. I'm going to pick up on one thing that Attorney Court said, which was that the officers committed the offenses. If you look at the letters that are in the appendices, none of those sample letters reflect convictions. The two cases that are criminal cases reflect pending cases. They're both pending cases. And the third one that contains no redaction, the whole point of it is to show that the Northwestern District is not willy-nilly saying we want to protect police officers. What they're doing is only protecting what constitutes Corey. And the reason that the Corey law exists, it's to protect people who, the privacy of people's criminal records, including people that are, at least at the time that these records were generated, these Brady letters were generated, had pending cases, not convictions, right?
Why does that distinction make a difference here?
Well, I'd suggest that it for whether it's a public record, I think I got to make a couple of leaps to get there. But just stepping back to why is there an exemption? Why is Corey a protected type of information? I think this is a pretty good example of why. It's to protect the criminal offender information against widespread dissemination, and here the criminal offender information are pending cases. And the fact that the people in the letter are police officers is irrelevant. Their status as police officers is irrelevant to the Corey statute. Very relevant as to why the letters are written to begin with, which I'd like to go there.
I'm just not
Sure.
following your point.
Sure.
Why does it make a difference for public records purposes, or for Corey's status, whether a case is pending or complete?
It doesn't.
Okay.
What I'm saying is that it's to me the fact that people's criminal records, as you've seen and I've seen, contain lots of information. Often they contain information that includes cases that don't result in a conviction. I'd suggest that that's one of the reasons that there is an exemption to the public record statute for Corey information, because these non-convictions are some of the information that are contained in criminal records. That's what I was getting to.
I get it.
But if I can get to the letters themselves, the District Attorney's Office for the Northwestern District, which is the chief law enforcement officer for that district, has an obligation to provide to criminal defendants in criminal cases Brady information, both under the U.S. Constitution, under Rule 14, and under 3.8D of the professional rules. And the information that they provide in these letters, some of which constitute Corey, some of which we argue does not, is to satisfy that obligation. These letters are transmitted, as you can tell, from District Attorney's Office to defense attorney for a particular defendant, and then, but they're not filed with the court, which I think is distinguishable from the analogy of going down to the court and getting the same information. This isn't information that anybody would get from the court, because these aren't filed with the court. These are transmitted to a defense attorney.
Okay, I thought the question before me, though, was not as to the letters themselves, whether the piece of paper should be disclosed, because you've already disclosed it.
Right.
The only issue is the specific information redacted. And
right.
Let me just read back to you what I understand the issue to be. It is whether the name and docket number of the recipient defendant essentially should be redacted, is Corey, and whether the name and docket number of the officer whose information is being disclosed is Corey.
Correct.
Okay.
Right, and I would suggest that as to the first example letter, JA 56 in the record appendix, this is one of the this is a letter that contains the name and docket number of the recipient defendant, the recipient defendant, and I would suggest that the combination of name and docket number is Corey information, and so that's why those redactions are reasonable from the district attorney's office and should not be should be accepted by the court effectively here at the summary judgment stage. And then as to, I think, the reason for the letters, as to the police officer information, I'd suggest that the police officer information that is contained in here would have the officer's name. That's obviously blacked out. But it says the date of the offense, that it identifies that it's a criminal complaint, it identifies the charge, and it identifies the court, and it also identifies the case status, which is that it's a pending case. And if you, on page 8, at the bottom of page 8 of our memo, cites the records compiled concerning an identifiable individual, the information that's blacked out would make it possible to identify this individual in connection with the criminal offense, the court, the status of it. I think it's inferable if the person's a police officer, they're over 18. So these redactions are the bare minimum redactions. I could conceive of a world where different redactions are made that would also comply with thread this needle to comply with Corey and comply with the public records law. But there's a name, and for the police officer, as to the first example, it's just the person's name listed twice. It's the only thing that's removed, because the letter, as it happens, doesn't contain the docket number for the Greenfield District Court case for that officer. The next one does. And so it's an exemplar, so it doesn't have the name of a defense attorney, but it's ready to go. And it does contain the docket number for the officer, and the person's name. Those pieces of information are what would lead anybody to be able to create a shadow criminal record of this officer. And I'd suggest that it's distinguishable from the Middle District case. The Middle District case was something like this. Middle District, send us all the corruption cases in your district. Here, that by definition of what is sought, it's going to seek a category of type of case, and is not going to elicit the full criminal record, and nobody's going to say, and it's not implied that the full criminal record of somebody is going to be produced. Here, I wouldn't suggest that full criminal record is what's required, but it's going to provide for these police officer disclosure letters. The point of them is that the person has a criminal case, right? And so here it's a pending criminal case, although these cases were, these public records requests and the letters went out prior to the McFarland and Graham cases. I would suggest that it's pretty well circumscribed, at least now, that a pending criminal case, a criminal conviction, a finding of civil liability relating to work to a police officer's job, all those things have to be disclosed, or at least in the, under the case law as it exists now, as it's been clarified now, those are the types of things that would need to be included. I can't stand here because I haven't seen any of these officers' criminal records, but the way the letters are written, it leaves the impression that they are the full and complete record of this person. That's the point of the disclosures, and so that's why I would suggest that in this case, the facts here are distinguishable from the Middle District case. I would say as to just the last, just to complete the thought on the last exemplar. Mm-hmm. The last exemplar is a disclosure that a police officer, looks like 20 years earlier, approximately, had testified untruthfully in a criminal case of some other person, of a criminal defendant, not the officer. The officer is identified by name. The officer is identified with the police department that he worked for. And I'd suggest that this shows the good faith, which matters to some extent under the public records law. the good faith that the Norfolk DA's office was acting with when it is trying to thread this needle. It's not just anything bad about police officers we're not going to show, and we're not going to give you the name. Here, this is obviously pretty damaging to this police officer, and if this person's called as a witness, could be impeached with it. It's turned over because it's not Corey. And it is where I think that the court can find that the DA's office was acting reasonably. I think you can also find it, Your Honor, in that the DA's office was meaningfully engaged with Mr. Khmer and later with Mr. Courts, had been meaningfully engaged with the supervisor of records at the Secretary of State, and was in this position of not wanting to violate the law. If they produce Corey, they're the chief law enforcement officer for that district. They don't want to be in a position where they're violating a criminal statute. And notwithstanding what the supervisor of records say, I don't think that they can tell the DA's office to violate a criminal statute. They sought help from the Attorney General's office. They didn't get it, and as a result, we're here. And I suggest that based on the agreed record, there is no violation of the public record statute by the Northwestern District, and you have everything you need in front of you to find that on summary judgment and award summary judgment for the defendant and the DA's office and against the plaintiff. Thank you.
All right, that was very helpful, and I take your comments about the good faith of the Northwestern District Attorney's Office as sort of background information about the position that you're taking, and that I do appreciate that you're sort of that the defendant is between a rock and a hard place here, that it is a concern not to violate Corey should it ultimately be determined that this information is Corey, and that it certainly makes sense to me that you would need a judicial determination of whether this constitutes Corey. I don't, as I understand it, the issue of reasonableness or good faith is not actually before me for decision. The issue before me, as I understand it, is solely the question of, is this a public record or is it within the exemption for under A for Corey material?
I think that's right, but I say it not just by way of background, but almost by way of preview. If there were bad faith, that could lead to attorney's fees and punitive damages. And so I do say it was a little more behind why I said it. That, and I just want to be.
I understand, and although that issue is not briefed or before me, I certainly had that first impression reading the papers that this was an issue that where the parties did need a judicial determination because of the rock and a hard place problem. All right, Mr. Courts, do you want to add anything?
Might I respond just briefly to a few of those points? On the question of the docket numbers, so defense counsel referred to page 8 of their brief, which lays out what constitutes Corey, but leaves out the following section, which says that despite that, the following shall be public records, and one of the items in there is chronologically maintained court records of a public judicial proceeding. And on page 382 of Middle District, the SJC held that docket numbers qualify as chronologically maintained court records of judicial proceedings, and therefore are public records despite the definition that's quoted on page 8 of the brief there. Also, in regard to the purpose of the Corey Act, I think that the page 290 of DCJAS is really helpful here. They say the first goal of the Corey Act is to limit the dissemination of someone's state-compiled Corey report to only authorized recipients. And in that same paragraph, they say, we are unwilling to declare that the Corey Act absolutely protects from disclosure all records concerning offenses that were dismissed prior to arraignment or never reached arraignment. In this case, it was two police officers from various places in Massachusetts who had DUIs. Boston Globe asked for the arrest reports and the booking photos. Those were disclosed despite the Corey statute because they said the Corey statute is not a prohibition on disclosing public records that talk about criminal, they talk about arrests, they talk about charges, they talk about convictions. It's a prohibition on disclosing someone's state-compiled Corey report.
So the distinction you're drawing, I think, is between an individual case, which is revealed by these documents, and a complete compilation by the state,
Right.
which it seems to me these documents would not reveal.
Yes, exactly. And then briefly on the good faith, we did brief the question of attorney's fees and punitive damages at the end of our motion, and we are asking for both attorney's fees and punitive damages here. So I wanted to speak briefly about good faith. It's true that Northwestern District Attorney's Office did release some of the previously redacted information. That was after 3 rounds of review in front of the supervisor of records, who all 3 times found in favor of Mr. Khmer, and after we sent a demand
Let me
letter.
ask you about that.
Yes.
The supervisor said that the information in these letters is not Corey. Why? As to the officers, why?
Following Middle District, saying that
I read the supervisor to be saying because the Brady letters were compiled after the fact.
Yes.
And I didn't understand that.
that we read that as an alternative that was brought up, I think, on the second round of appeal. I think the initial finding was under Middle District, names and docket numbers are not Corey, and it was a relatively brief summary of the law there, I'll admit. I think on the second round of appeal, the supervisor of records also noted, and I may have this backwards, I apologize. At one point, they did note that because these were not compiled for a criminal history report, but were actually compiled by an administrative agency, not as part of the judiciary, and not through Corey or the iCorey system, that there was another reason they fell outside the ambit of the Corey statute. I think that more goes to the issue of whether the records as a whole are Corey, as opposed to the individual names and docket numbers, which, as Your Honor noticed, is something that the parties are no longer disputing. We're really just talking about the docket numbers and the names at this point.
All right. Would the supervisor's determination make any difference with respect to whether the district attorney's office violated Corey if an appellate court later determined that this information was Corey?
I think it would, in the fact that there is a carve-out from liability for good faith disclosures that are made during an agency, a pursuance of an agency's official duties. We read responding to records requests as part of official duties, and so we think the safe harbor would apply here. I'll also point out on the question of criminal liability, the Northwestern District Attorney's Office has disclosed an awful lot of information about its prosecutions of other people on its website. Just yesterday, they posted a woman, her name, the court that her case was heard in, the charges, the outcome, the conviction, and the sentence. 2 weeks before that, they had the same information for a man who was convicted, and they also included information about prior offenses. There's a lot of information, if you go on the Northwestern District's Attorney's Office, that seems to meet their definition of Corey, with their strict reading that you cannot release any information about a criminal proceedings. If you go to their website, they're really concerned about criminal liability. It seems like, they're not taking it that seriously.
Okay. All right.
I would say it's outside the record.
Sorry?
It's outside the record.
I was thinking that's not in any, I don't have that information in front of me.
We included it in our briefs.
All right. I will review the papers and I'll review any evidentiary material you've submitted in support. All right. Thank you all very much. This is a very interesting case.
Thank you.
Thank you,
Very
Ron.
well briefed.
Thank you. Thank you.
All rise, please.
Goodbye.